Okay. So we will be having our mental health diversion program, a multi-agency panel discussion today. We'll be having Judge Nancy Ayers joining us today, Michael Rodriguez, who is a Chief Deputy Public Defender, joining us, Mae Fox, who is a Senior Deputy District Attorney. We'll have Doug Ridley, who is the President of the Ventura County Criminal Defense Bar Association joining us today. We will have is it Declane Tormey, Supervisor, Deputy Probation Officer, Jessica Rose, Ventura County Probation, who handles the mental health diversion program. We have Mike Rodriguez, who's a psychologist and Ventura County Behavioral Health Services, and we will have Dr. John Shipper, psychologist and Ventura County Behavioral Health Chief of Adult Services, joining us today. So Dr. Shipper, would you like to maybe give us a brief overview about either the panelist or what we'll be hearing today?
Well, let me just first check. Can you hear me?
Yes, I can.
Good. All right. I'm having, of course, today of all days, I'm having a little bit of internet connectivity problem. And now I've shared the screen. Can you see the PowerPoint?
Yes, we can.
Excellent. All right. So I don't want to occupy any time other than to say I'm going to be advancing the slides for the folks as they talk. I think what would probably be best, if possible, if you have questions, to share those questions or put those questions into chat. And then once everybody has had an opportunity to kind of speak to the program from their perspective, everybody I know is happy to entertain the questions. And if it were to happen that we end up with more questions than what we can address here live, we'll be happy to answer all the questions and make sure the answers get out to folks when we send the PowerPoint after today. So if that's all good and understandable, I will leave it to Judge Ayers to get us started.
All right, can everybody hear me?
Yes.
All right, good afternoon, everyone. I'm just going to go briefly over the law and talk to you about a little bit about what we did when this law started. As the PowerPoint indicates, John, you need to go to next page. Page 2.
You seeing that?
Yes.
Yes.
Good.
All right. The initial law that enabled diversion, mental health diversion, was enacted in June of 2018. It was kind of a sleeper bill. It was attached to a fiscal budget bill, and the first version of Penal Code Section 1001.36 was modified in November of 2018, and the version that we're working with now we became effective in January of 2019. And when we found out about the law, we were all a little surprised because it was, like I said, no one had really vetted it with the courts or with anyone. The initial bill as it stood allowed almost everyone to be diverted on mental health diversion, but the final version of the bill excluded certain types of crimes. And there aren't very many that are excluded. Murder is excluded. Any crime that would require a person to register pursuant to Penal Code Section 290, which is sexual offender registration, is excluded. Rape is excluded. Child sex crimes, serious child sex crimes are excluded. And rape and assault with intent to rape. And the code, in order to be applicable for mental health diversion, you do have to have a diagnosed DSM-5 diagnosis, with the exception of 3 that are excluded, which are antisocial personality disorder, borderline personality disorder, and pedophilia. if we could go back to the first slide, just for a few minutes, I just want to talk about what happened when this law came into effect. It created some problems for the counties generally throughout the state of California. And the problems is that although the law was enacted, it didn't provide for any funding to implement the provisions of the law. It also gave us no guidelines on what the diversion program should look like. And as such, every county was left to figure out for themselves what resources they could devote to it and how it was going to work. In addition, of course, because there were no resources provided, we didn't get additional judicial staff or court staff, or neither did behavioral health, or neither did the public defender's office or the DA's office. So we were given this law and they just said, do it. And so the first thing that we did as a county that was really good is that we formed a multidisciplinary team to figure out what we were going to do. And the team consisted of the DA's office, the public defender's office, behavioral health, the sheriff's office. Probation even was on board initially, although they weren't sure whether they were going to participate because it's pre-plea diversion and they only supervise probationary people. Of course, the court devoted staff to it as well as myself. And then Mr. Ridley from, excuse me, the private defense bar also joined our team. And we met to discuss the proposals and point of view of everyone in the multidisciplinary team. Some of the first things that we discussed were privacy concerns, because you can imagine with mental health treatment, there are significant privacy concerns. We discussed the necessity of treatment and what type of treatment was going to be provided. And we eventually got probation to agree that they could assist us with the program in regards to supervision and testing, because as a lot of people know, often with mental health issues, someone can have a co-occurring substance abuse problem. So that needed to be part of an effective diversion program in the courts, in everybody's opinion. And so probation joined in. And I'll let Ms. Rosa and Mr. Torme talk about what they do in that regard. We talked about hearings on violations. We've talked about termination proceedings. We've talked about treatment provider reporting requirements, judicial discretion, because there is a discretionary aspect to the mental health diversion component. We talked about what role behavioral health would play. And initially they committed to 20 people, and we far exceeded that now. We talked about, we've had problems with people who live out of county and are getting treatment out of county, danger issues with regards to community safety and frequency of reviews. I'm happy to say that the committee works very well together, despite all of our different opinions and viewpoints on the diversion program. It's been the best thing that we ever did. We still meet frequently to update things. And I think one of our goals in the future is going to be to actually have a written memorandum of agreement that we can work out. The legal requirements to be considered for diversion are that this person suffers from a qualified DSM-5 diagnosis, that I'm satisfied that there is a sufficient nexus between the mental health diagnosis and the commission of the crime. And that is a significant issue. I'm using the PowerPoint. Dr. Shipper? Did everybody else lose it or just me?
I think we may have lost Dr. Shipper completely.
It's his internet connection.
If you want to make me the co-host and give me the ability to do
There he
screen
is.
share, I've got the PowerPoint up, or Dr. Shipper can do it now that he's back.
Sorry about that. So you've lost my shared screen, I would trust.
Yes.
All right,
I'll just go on, while Dr. Shipper is working on that, not to take up time, I'll go on with the legal requirements, and then by that time the screen will be up. But the nexus issue, as I said, there has to be a sufficient connection between the defendant's mental health issues and the commission of the crime. There has to be a mental health opinion that the person's symptoms motivating the criminal behavior will respond to treatment. The defendant needs to consent to diversion and waive his right to a speedy trial. also agrees to comply with treatment. The one other thing that is important is that the defendant does not pose an unreasonable risk of danger to the public safety. And that actually has a legal definition that is pretty hard to meet. And the court has to be satisfied that the recommended mental health treatment will meet the specialized needs of the defendant. And my own component that I add to that is that it will also keep the community safe. There's a few other things that I wanted to add with regards to that. It's very important to me in deciding whether to grant mental health diversion that the treatment proposed will meet the specified mental health needs of the person. And I do have discretion, even though all of the qualifications are met, to exclude someone from diversion on my own. And I take that discretion very seriously. And I listen to everybody. I read everything. I consider the treatment that's going to be authorized or that's proposed before deciding whether to grant diversion or not. Once a person is granted diversion, there's only really 3 ways that they can be terminated from diversion. And that is that if they're charged with a new offense or engaged in criminal conduct, that the defendant is not performing satisfactorily in treatment, or they become gravely disabled and are conserved, they can no longer be in diversion. But I kind of like to think about what we do as a collaborative court, because even though we all represent different sides in this matter, I think that all of us really try to keep people in treatment as best as we can and keep the person safe and in our program, because I'm convinced that it has more benefit than any downsides to it, as long as somebody's current with treatment. So just quickly, the observations and the numbers. Most people are meeting criteria. We have some problems getting follow-up reviews, and I'll discuss that just a few minutes in just a few seconds as well. That my conclusions are basically the problems that we're experiencing the most are getting detailed treatment plans, especially from private providers, and getting progress reports from treatment providers, which are required by the law, are required by our program, because we have to know that somebody's still taking their medication or going to treatment. The numbers speak for themselves. We have 57 current people in diversion. The majority of those you can see are 43 are felony charges and 14 are on misdemeanor charges. Almost everybody's in good standing, with the exception of 5 people that are still participating in diversion that we're trying to get back on track, but have pending violations and pending referrals. We still have 23 people that have applied for diversion that I haven't made a final decision on yet. We've had 9 people graduate from diversion. The first person as a felon who was put on graduated in January, and we have 8 misdemeanors, excuse me, that have graduated. So that's the court's perspective, and I'll be happy to answer any questions at the end of the program. Ms. Fox, to you.
So, Ms. Fox, would you please unmute yourself?
Did that work? Okay, good. I couldn't unmute myself. I apologize. Thank you for having us. My name is Maeve Fox. I've been with the District Attorney's Office for 31 years, and I've spent the vast majority of that time prosecuting serious cases in our criminal court system, which is an adversarial system. So that's what I wanted to point out for you today, is the difference between the diversion program authorized under Penal Code Section 1000.2 and typical criminal cases. What happens in a typical criminal case, as you might know, is that charges are filed by the district attorney's office. The defendant has certain rights, and we go through a very formal process, which includes potentially a jury trial and a preliminary hearing if it's a felony, or jury trial if it's a misdemeanor. We proceed on to sentencing if the defendant is convicted. So in this case, with the enactment of the law, for the first time, really, there's a diversion option available specifically for people suffering from mental health issues, when those mental health issues basically are causing them to engage in certain behaviors which cause them to come into contact with the judicial system. So this is a great program for the right people, because the end result, as Judge Ayers indicated, is at the end of the process, if the person is successful, all the criminal charges are dismissed. So when the team was discussing this presentation, and the reason why we have this slide up in front of us is because the question is, doesn't the district attorney's office oppose diversion in all cases? Don't we want to see everybody go to jail and prison, et cetera? Well, the answer to that is no. We want people to succeed in this program just as much as everyone else. The revolving door of criminal prosecution of people who are mentally ill certainly exists. And it exists in this county, and it exists everywhere else. So giving people the opportunity to engage in treatment with the expectation and the hope, especially on the part of the district attorney's office, but everybody, that we never see these folks again involved in the criminal justice system. That's the goal. So in order to get there, as Judge Ayers mentioned, they do have to give up some very important rights. They have to give up their right to a jury trial and to a preliminary hearing if necessary. They have to give up their right of confidentiality, which is a big deal in some cases, especially regarding HIPAA. And one of the other biggest differences in the program, as opposed to the regular criminal justice system, is the burden to get the program rolling for a particular client is on the defense. So we really like that. They make an application, they contact behavioral health, they seek out a treatment plan, which is going to address the particulars of each client's issues, as well as satisfy the judge. And then the district attorney's office is given an opportunity to file a written response, whether we oppose or we do not oppose mental health diversion. And in very many cases, we do not oppose it. And so we're happy to see people that fit the program, get into the program. We're even happier to see them succeed with the help of probation and mental health. And we're really happy if we never see them again. So that is a real benefit, and it is the real goal of every single person on this team. We have terminated people from diversion, as you saw the statistics that Judge Ayers put up. It's not that common, but this isn't the right kind of a program for somebody who is not ready to address the ultimate issue. This is a program for people who want to work to improve their situation, stabilize, and hopefully improve their lives in order that they don't have any further contact with the criminal justice system. So we require pretty strict compliance because it's a voluntary program. You have to participate. You might have residency requirements. You might have counseling requirements. You might have medication requirements and non-compliance. And you have to see the probation officer in most cases, as well as a psychologist and or psychiatrist. If we get reports from the
Seems like the internet is not being kind to a lot of us today.
I couldn't tell if that was me or if that's Miss Fox. So it's Miss Fox who's lost audio.
and video, it looks like. So I suggest, John, are you back, Ms. Fox?
I think so.
Yes, you are.
Okay.
The most common reason why we would oppose a person's participation in mental health diversion would be the risk to public safety. And Judge Ayers addressed that a little bit. But we look for a real close nexus between the mental health symptoms and the reason for committing the crime. And we also look for whether treating the person in the community is going to be a safe proposition. And if it is, and if the crime is connected to the mental illness, then we generally do not oppose it. And at that point, it's up to the participant. And we, again, wish for success in all cases. So I think that's about all I have to say, and I'll turn it over to the next speaker.
Good afternoon. My name is Michael Rodriguez. I'm a Chief Deputy Public Defender. I've been a lawyer for nearly 30 years, been in the office for over 16 years. And within our office, one of our guiding principles is that people suffering from mental illness should not be incarcerated or prosecuted because of their mental illness. Now, we represent clients suffering from mental illness in several types of proceedings, including criminal and juvenile delinquency, LPS conservatorships, psychiatric hospitalization, REIS petitions, assisted outpatient treatment, and probate conservatorships. We litigate and collaborate as is appropriate, seeking meaningful access to mental health services and treatment that is specific to our clients' needs. We continuously strive to expand meaningful access to appropriate mental health treatment for our clients. Mental health diversion is one means which provides incentives to those who have not had meaningful access to mental health treatment or were treatment resistant. And so what does the process look like? And that's what this slide addresses. First, we must file an application or motion with the court that includes documentation and information regarding our client's mental health diagnosis, establish that there's a nexus between the diagnosis and the alleged offense or offenses, and a treatment plan. Generally speaking, from the time we filed the application or motion until the date of the hearing on the mental health application is about 4 to 6 weeks. There's a variety of things that happen in that interim process. Generally speaking, after we file, it's 1 to 2 weeks for the district attorney's office to file an opposition. Then time for the court to review the moving papers and the DA's opposition. And at times, the court requires a revised or updated treatment plan. And so with all this going on, oftentimes it takes 4 to 6 weeks from the time we file the application to the time we have a hearing. With respect to our in-custody clients, they are released to CRT as soon as space is available. And now when I say as soon as space is available, the application for mental health diversion may still be pending when they're released into CRT. So the idea is to get folks into appropriate treatment as soon as possible. And then once a person is accepted into mental health diversion, the court generally sets reviews every 2 weeks. And then as our clients progress and are in satisfactory compliance with the terms of diversion, then the period of time between reviews gets expanded. The duration of mental health diversion depends on whether it's misdemeanor or felonies. For misdemeanors, it's generally 1 year. For felonies, it's 2 years. And then at the end of the case, as has been referenced already, if our client has successfully completed mental health diversion and the case is dismissed, and under certain statutes, specifically Penal Code Section 1001.36E and 1001.9A, the court may seal records, and the client at that point may state that they were not arrested nor diverted on the cases that were diverted. And so it's important to note, though, if a person is on probation for other cases, those cases won't get dismissed. But the diversion case is the case or cases that are in front of the court where the application for diversion has been made. And, it's important to know that the other thing is with respect to our role in the process is that we are strict advocates for our clients, which means that we advocate based on what they wish. So if mental health diversion is a voluntary program, if they wish to apply for mental health diversion, we advocate for their admission. If they do not wish to apply, then we don't. And so it's important to know that what our role is as far as within the whole, in this case, the criminal justice process is our role as their attorneys, which may differ in our representation in other types of proceedings, including certain aspects of probate conservatorship. And if you have any other questions, by all means, feel free to ask at the conclusion of our panel discussion. Thank you.
I'll go ahead and hop in and address just some of the differences with clients who hire private attorneys versus clients that are dealing with the public defender's office. Because in my firm, I started out my career in the district attorney's office, so I understand a lot of where Maeve is coming from when she's working on those cases. Not completely, of course, but to some extent. And then with the clients that are coming into my firm as a privately hired defense attorney, it's typically mom and dad or some sort of family member that comes to us that is looking to hire a private defense attorney for a family member who is suffering from a mental health issue and then ends up in the criminal justice system. From my perspective, it's some of the most rewarding cases we can work on because we're scooping up the whole family and getting them to rally behind the family member who has been suffering and oftentimes has been having problems for a really long time. Most of the clients that we're dealing with in the private field have their own health insurance, which is a little different too. They may have been going to a private psychiatrist, private psychologist for a while, or the family might have connections into a private provider. And that's a little bit of a different challenge for us. You'll hear from behavioral health in just a few minutes. And in my experience, the process of plugging into the fantastic behavioral health system that we have, they already have a lot of the infrastructure set up that can allow these clients to come up with a good solid treatment program and to work collaboratively and to have the reports come in on time into the court so that Judge Ayers is happy and she has what she needs. In the private world, we're usually dealing with a doctor who may have never even heard of this program before, may have never dealt with the court system before. So not only are we working with the families and trying to guide them through the process, but oftentimes I'm on the phone with a really smart psychiatrist trying to convince them why they should put certain things in writing so that we can give them to a judge and make sure that everyone understands what's going on with that. So it's a little bit more herding cats, I think, when we're dealing with private clients and their private insurance. It falls on the defense attorneys. It falls on me to make sure that all the reports are in on time and everything's happening so that it is just as smooth of a process, hopefully, as it would be with behavioral health. And that's not to say that the public defender's office isn't working with private providers from time to time, because they are. And that's not to say that I'm not working with behavioral health, because I do have clients that are clients of behavioral health as well. It's just, I find more often than not that when I'm working with mom or dad or specific family members, that is who we're interfacing with even more. It's that support system that outside of court that provides that assistance to family members. And the rest of the nuts and bolts of it, Mr. Rodriguez did a fantastic job of explaining, so I don't need to repeat that. But that was the one thing that I wanted to shine a light on with my part of the process. And it's one of the reasons why it may not seem like we need two different defense attorneys on this panel and on this work group, but Mr. Rodriguez and I just have just a slightly different focus when we're dealing with clients, just because of the nature of how we're retained and how we're brought on cases. And again, happy to chime in later whenever anyone has questions about my process and how I'm seeing that. Dr. Shipper, I'm not sure who we have next, but I'm happy to turn over to the next slide.
That is going to be behavioral health.
All right. Well, it's good going towards the end because you guys covered a lot of the information. I can get right down to the matter here. So my name is Mike Rodriguez. I know I see a lot of familiar faces out there. It's good to see everybody, even if it is through Zoom. And I coordinate a lot of the treatment that goes through the court system for Ventura County Behavioral Health. So as the slides we'll look at here, and it's already been discussed, the treatment isn't isolated to Ventura County Behavioral Health. You got folks that are using private insurers like Kaiser, Beacon, other private providers that are in practice for themselves. And there's a whole culmination of providers out there that have been willing to take that jump. When we talk about behavioral health, VCBH, we had made an initial commitment of 20, and those 20 have grown now, and I believe we have somewhere around 50 on the books being considered for mental health diversion. And they cover pretty much every one of our clinics and programs from east to west county, north to south. So from our 18-year-old TAY clients that we have involved, all the way through our older adults program with the folks that are, the seniors. So every program is touched by mental health diversion, and we've got a lot of staff out there. We're talking about VCBH and infrastructure, kind of what Mr. Ridley was inferring there, is we've got a lot of staff helping people and doing good work out there, and it's a beast. So we've got case managers, therapists that are available. We've got psychiatrists. We offer groups. There's all kinds of referrals that we make to our alcohol and drug program and other outside agencies. And we really focus on a team approach. So VCBH really kind of is the foundation for a treatment team approach when we're talking about mental health diversion. So it's important to know that, as it's been mentioned several times, the voluntary nature of treatment for mental health diversion. And I think this is where, we could probably have a whole other discussion with our NAMI friends, because a lot of times we know that some of the people we want to reach aren't volunteering for services just yet. They're not in that space. And unfortunately, for mental health diversion, that's one of our limitations. However, for those that are willing to do it, we've got a heck of a program to offer them. And when we talk about treatment more specifically, it's kind of like a Goldilocks paradigm, where if you offer too many interventions, it could have a negative effect. And if you offer too little interventions, it could have a negative effect. So we're looking for just the right treatment plan. And that treatment plan is client-centered, and it's specified for each individual client as we go through. So if it sounds like a lot of work, it is, but it's worth it. As Mr. Ridley also said, some of the most rewarding work comes from seeing folks go from their lowest inside of custody to a graduate 2 years later after successfully completing the program. So I'll come back and briefly talk about our $2.4 million award that we were given for mental health diversion. But first, I'd like to tell you what could be expected from a couple of cases. So I picked out a couple of cases, generalize them so I'm not breaking confidentiality. But one from the West County we had was up for felony mental health diversion, mid-20s, and he didn't require a whole lot of intervention. So he was placed in a sober living facility. He had VCBH help him place him in a sober living home, and we helped him get back up on his feet, get a job. He worked full time through the program, and he spent 2 years, coming to weekly therapy, seeing his psychiatrist approximately once every 4 to 6 weeks. He was a part of 2 or 3 groups at any given moment, and it took him 2 years, but he made his way through the program. And on the lighter side of things, he was able to graduate with a minimally invasive program and really set this young man on the right path. On the other side of the spectrum, over from our East County, we had a client that came through. He was charged with a violent felony, and he required a much higher level of care. So he progressed from custody into a program we call crisis residential treatment in our community. We stabilized them in crisis residential treatment, has 24-hour staff, and they work around the clock to make sure that we're matching people back into the community with the right level of care. And then he went to a mental health rehabilitation center, an MHRC, the Hellmont House, and he spent the next 2 years at Hillmont House programming, learning daily living skills, learning independent living skills, and he was a successful graduate that actually transitioned out of that higher level of care, and he's into a next lower level of care as a graduate, and he's actually doing pretty well. So kind of give you the idea of the spectrum from people who really need some coaxing, some resources to get on track, all the way through to the 24-hour facilities that offer a much higher structure of care there. So with that, I'll kind of go back just really briefly and talk about the award from Department of State Hospitals that we were granted. And it's to find some more of those more intense participants. And the 2.4 million is really going towards staff and treatment to divert folks that are much more seriously impaired from going to a state hospital and spending a year or so at a state hospital, and really trying to keep them closer to family, closer to community, in the community, and finding a way to balance that out and go forward. And so that kind of covers the treatment side of things from VCBH's perspective. And you heard a little bit there about the private providers as well. And then of course there's some overlap and everything in between, but I think that covers our treatment side of things.
I didn't know,
I'm sorry, John.
Dr. Rodriguez.
Yes. I was going to mention one last thing that I think is very crucial is when we have the clinical dilemma here. I missed that last point on the slide. Thank you, John. And it's for VCBH. The spot that we find ourselves in is we, boy, folks that work for VCBH have it in their heart to work with the community. They work with difficult clients day in and day out, and we're in it for the long haul. We want to be there. We want to see a person succeed year after year after year after year. And we know these are very difficult situations for folks to be in. So we do get kind of caught in the middle, if you will, because on the one hand, when we talk about voluntary treatment, we don't want to burn our bridges with an individual or family by forcing treatment when a person's not ready for treatment. And on the other hand, we also want to be open to that long term. We want to see the horizon on the path. So we partner with our friends over at probation. We partner with the public defender's office and the district attorney's office to try to find that right balance of how do we really keep a person in the bounds of what their mental health diversion terms are, keep them engaged in treatment, keep them moving along without alienating and without really burning any of those bridges to treatment, and keeping sight on that future goal. So that kind of moves us into our next slide. Thank you, John.
All right, probation is up.
Good afternoon, everyone. My name is Declan Tormey. I'm the supervising deputy probation officer in charge of the mental health diversion officer, Jessica Rose. Probation's role in this process is kind of the same, but different for normal probation. We are acting as the eyes and the ears of the court. When someone is referred over by the court, we prepare a report that discusses the terms and conditions that the court would likely be interested in. We make no recommendation on whether or not someone should be eligible to participate in mental health diversion. We really function as an informational font for the court itself. My officer is appearing in court twice a week, so if there's questions that need to be asked. Once a person is granted probation, Jessica Rose is the only officer that supervises, or excuse me, mental diversion. Jessica Rose is the only officer that supervises those clients. So it's a direct point of contact. They see her in the courtroom, and if they get diversion, they are meeting with her as per the terms of their grant. She contacts them by phone. If the court requires drug testing, we drug test. If the court requires home visits, we'll go out and do home visits. In a diversion realm, we don't have the authority to go out and arrest a person that's on diversion. So if there are violations occurring, we're simply providing those to the court and the attorneys and making no recommendation as to what should happen. We provide the information and then let the court and the attorneys decide what's going to happen with that client. So definitely the supervision aspect is similar, but what our role is in that supervision is definitely different. And I
All
think that's
right.
pretty much it for us. I mean, our role is very limited in that, we're just reporters of information at that point.
All right. So that's sort of what we had prepared and anticipated there'd be some questions. I don't see any questions coming by way of chat, and I don't know if people have questions that they want to verbalize or how you'd like to proceed, Roberta.
Dr. Shipper, it's Judge Ayers. If you would take down your PowerPoint, we could all go back to full screen viewing. Just a suggestion.
I will do that. That's a good one. All right. That's what happens when you do such a comprehensive presentation. You answer all the questions before they ever get formulated.
Roberta, if you were saying something just a moment ago, we couldn't hear you.
Yes. The only question that I see in the chat, it says, what is CRT? If somebody can answer that.
I think we
You want
did.
to speak to that?
It was
Sure,
my
Dr.
question.
Rodriguez.
It was actually my question, and I heard it from one of the doctors or presentators. It was the crisis residential treatment. I know everything has an acronym, but I didn't want to assume. So I do thank you. I did get that answered.
And that's
we
the
use
only,
CRT. It's basically a step-down facility. So it is a unlocked 24/7 treatment facility. It is on the campus up there at DCMC. And so it's not at all, like what's been alluded to, it's not all unusual for somebody to go from jail, obviously a locked setting, where they're saying they want to be involved in mental health diversion. And it's, in some instances, it seems like the right thing to do. And sometimes it seems like the right thing to say, even if you don't entirely mean it. And so when a person steps down to CRT, which is unlocked, that's really in a sense where we begin to see if the person is really behaviorally committed to the idea of treatment, because they can walk away if they won't want to. And if they hang in there, then it gives us a place from which to sort of find a more appropriate longer term placement.
then let's see. Let me go ahead and read a couple of the other questions that we have in the chat. It says, where is actual case management in this process? Meaning actual case workers to meet with these clients and monitor, advocate, assist throughout the process.
You want to speak to that, Dr. Rodriguez?
Could I hear that question again? Am I looking in there?
Where is actual case management in this process? Meaning actual case workers to meet with these clients and monitor, advocate, assist throughout the process.
So that's a great question. I'm assuming that's related to COVID and how involved we are. So it's going to vary depending on what program and clinic that the participant is open to. But with our forensics team is been kicking all the way through COVID, and we're still getting out to the jails to interview folks. We're still meeting with people at the Ventura Clinic for forensics-based evaluations and court-related matters. So it's a combination. There's a lot more telephone work being done from our clinics and from our treatment programs. But for our forensics program, which is kind of an ancillary program that supports our clinics, the staff that work with me, we're still seeing people face to face. The case management is still happening both with phone, in person, sometimes at court. So it's a combination, but a good question on with COVID going on. So we haven't had the luxury of being able to connect with folks as much with Zoom or telephone. We've still been in person, but some of the clinics have a little more telephone based versus in-person case management. I hope that answers it.
Yeah, there was another question, and I think it says because
let me just add, if I can, Roberta.
Mhm.
I might just add one of the distinctions about mental health diversion from at least the treatment point of view. Unlike some of our other forensic programs where there's a dedicated staff, with mental health diversion, like what Dr. Rodriguez was talking about, essentially the treatment, whether it's psychiatry, case management, individual or group therapy, are delivered at the level of the clinic. So if a person living in East County was to become involved in mental health diversion, they would get their treatment, at least the county treatment, if they were a county client, on contrast to the private pay. They would get their treatment by way of the clinic nearest to where they live and still be able to participate in mental health diversion. There have been other past forensic programs that have been more centralized, and while it has its pluses and minuses, it does place something of a burden on the participants. So if there's the expectation that somebody gets from one end of the county to the other end of the county to be seen for treatment, it can have its challenges. So what it does is it forces, and right now that task is a little bit too humble to say so, but that task falls on Dr. Rodriguez and to a large degree probation to sort of help sort of monitor and be able to report to the court how conscientious, how dutiful folks have been in follow-up, because again, that treatment has been decentralized.
Okay, the other question that was similar, it says, because of COVID, has it been more difficult to stay in touch with the diversion clients? So I think you've answered that.
And I would even add with the difficulties, and I'm sure the partners on the panel would agree, one real big loss from COVID has been the inability to have our clients at the courthouse every week. It really reinforces our ability to engage people in treatment, to engage them in participation with probation, to engage them in participation with their own attorneys. And I think that COVID has really dealt us a blow with not being able to have the majority of our clients weekly or even bi-weekly in court. So it's been a major impact.
Okay, another question for you, Mike.
Well, I was going to say, one of the other COVID impacts for us, we mentioned CRT. So there have been times in the past year where CRT has been COVID impacted. So they have either a positive case or they're on essentially sort of a containment. And it's just one of the placements. Several placements have struggled through the same thing. And it's had the effect of causing people to be delayed, so to speak, in the pipeline. So if you can't move out to CRT, or you can't move from CRT to the next placement, the whole thing kind of grinds to a much slower sort of pace than what we would generally like to see for folks.
Okay. Another question for Mike is, why does it take so long to get treatment at VCBH?
Good things are worth waiting for. No, I could definitely understand some frustration with a lot of areas and getting treatment quickly. I think Dr. Shipper just alluded to some of it. A lot of our folks who've been in custody for more than a few months, I as a clinical person really like to use a crisis residential treatment kind of model to step them down from being in a very secure environment to a less secure environment before we set them into the community, so we can really see what is needed as far as interventions and treatment. So with CRT and licensing, we need COVID tests done. We need COVID tests done within 72 hours of the test being sent out to be transferred to the person from the jail to CRT. I mean, there's a whole myriad of complications in the nuts and bolts of getting a person from jail into treatment. Now, with that said, as far as getting a person opened up to VCBH or getting a person enrolled in services, that process, I don't believe has slowed down very much. It's just gone mostly by telephone versus in-person interviews. So we're assisting folks that are getting connected. If a person's still in jail or in custody and needs to be connected to VCBH, and CRT is not one of the options we're looking at, and we do have people from our STAR team that are going into the jail or setting up video interviews with the jail and getting them opened up. So I don't think that's been as highly impacted as the movement going through our crisis residential treatment or to any other facility that requires COVID testing. And then, of course, with our main jail has experienced several complete lockdowns with COVID, where they've really worked hard to stop the spread within the jails. And that's, you know, obviously been a great burden for the jail staff, and they've worked really hard to minimize the impact, but the impacts have been pretty severe with our treatment side of things.
Okay, there's another question. How effective is MHD in reducing recidivism?
I'd certainly defer to anybody else who's more up on the research here. My sense is it's a little bit early to know. There is, you know, my mind goes to one of our other forensic programs, mental health court. And I would be one who would be inclined to suspect that we might see some similar sort of a pattern of results. And what we were able, and again, this is tricky sort of relationship to demonstrate, because really, in order to figure out how effective a program like mental health diversion has been, you really need to be able to look at it 3, 4, 5 years after the program, after the person's participated in the program. Because what we're talking about are often long-term patterns of behavior. Folks coming through mental health diversion, not entirely, but to a larger degree, are folks who have a long history of repeated incarcerations. There tends to be something of a relationship between serious mental illness and repeated short-term incarcerations. So changing patterns is a difficult thing to do under the best of circumstances. And so to really sort of have that effect, you need a program that's of sufficient length, and then you need to be able to you need to really compare, say, 4 years after they were in mental health diversion to the 4 years before they were in mental health diversion. So what we're talking about is a fairly significant time commitment. And that's what we did with the mental health court. After we'd been running it for a length of time and had a group of people, we were able to look at it. And what we found, and what I suspect we might find in the future with mental health diversion, is that there's a statistically significant relationship between the length of time that the person's in treatment and the effect on the number of days they spend in jail subsequently. So the longer they're in treatment as part of the program, the less likely they are to have as many jail days after the completion of the treatment. So it's a negative correlation. It's a good thing. And again, it's a little early to know, but we'll certainly be looking at the numbers when we have enough data to draw from.
I have a comment. It's Judge Ayers. I just want to point out that there's a lot of different ways of defining recidivism. And so before we can even talk about recidivism, number one, we have to have some time period that elapses, which we don't at this point. And number two, we all have to agree on what recidivism means. Does it mean reoffending within 1 year, or does it mean reoffending within 3 years, or does it mean there's a variety of ways to define it, which makes tracking progress difficult to say. But I can tell you so far, we haven't had anybody repeat diversion. So.
Okay, this is kind of a comment and a question. It is great that this alternative is available. However, it seems as though the requirements are very specific and rigid. How much success do we expect to see if a person is unable to meet the expectations of the court? They end up back at square one. My loved one has seriously mental illness, and I have some serious doubts as to his ability to complete 12 to 24 months without ERR. This would lead me to lean towards just having him plead to avoid this. How would you address this concern?
I'd like to hop in if it's okay. From my psychologist hat on right now, and my marriage and family therapist hat on, working with families and everything. I think this nails it right here with our panel, and I'm glad you guys get to see how we work together. the real drive, the purpose. And I think, Ms. Fox was talking about it earlier. I know that Michael Rodriguez was talking about it, is to end that cycle, right? To end that revolving door. So as an honest question, how much should we expect somebody who's severely or persistently mentally ill complete 12 months or 24 months? They have a great chance once they get in my opinion. And I encourage any kind of conversation from our panelists, but they have a great chance. And the reason is they have a whole team of people making sure that path is illuminated. Now we may not be able to force them on the path, but we can illuminate that path and we can guide them to that path. And a person who is in diversion, everybody, whether they like it or not, attorneys, psychologists, judges, become personally connected because you're reading reports, you're hearing the progress, you're hearing the pitfalls, and you kind of have your own team cheering you along the way as you go. So I think that for a family member, a NAMI folk out there, one of our friends in NAMI, to have a family member that you're supporting in the process, the pleading out, yes, you'd get to see them a little quicker or a lot quicker. But the ending that door and to be able to see the growth and the progress is so worth it. To be able to watch somebody transform and to be able to take resources with the pluses and minuses as they go, it changes the game in my opinion. And I think that it's really worth the 12 or 24 months goes in the blink of an eye for us clinical folks and for the attorneys, because it's like we're on the edge every time a report's coming out and every time we're checking in and making sure. And I'm sure with the families, once they get the buy-in to the team, I think it would go quickly also. I'm sorry, I didn't mean to talk too much.
I would like to make a comment. Go ahead, Michael. I'll go after you.
Well, thank you. In the important thing is that one of our clients gets the level of and the nature and scope of services that are appropriate to their needs. And so that may look different in different circumstances. And one of the things I'd like to go back to is either the first or one of the very first people admitted into our county's mental health diversion, and I'm just going to call him Bob for the sake of anonymity, is that he was charged with a felony. He had been up to the Department of State hospitals for competency restoration in other cases, and he was kind of like going through that revolving door of psychiatric hospitalization, jail, streets, family, and kept cycling in and out. His family were at their wits' end, but wanting appropriate care for him. And what ended up happening in this case is that he's one of the success stories at the end. He completed his program and was the person who had a felony who successfully graduated this program and had his case dismissed. But if you were to look at it coming in, and if someone were to be placing odds on him, people would not be betting on him because of how acute his symptoms were at the time that he began the program. But by working through the program and receiving appropriate level of services, he continued to grow stronger and to be able to function out in the community to the delight of himself, his family, and his neighborhood.
I would just like to add something, is that this is not the first collaborative court that I've worked on. And the first one I worked on was now non-existent drug court. And the treatment is different and the goals and objectives are a little different than what we're doing in mental health diversion. But I felt when I had people that could come in that had been addicted to controlled substances for years, and they could be clean for 3 months or 6 months or even 9 months, and they would get services, they would know where to go to ask for help, they were provided all of this care, supervision by probation and assistance to stay off the drugs. I always looked at it as a win-win situation, even if they relapsed and ended up getting kicked out of drug court, because for that period of time, they were a success. And they were given the treatment and the access to help if they ever wanted again. They know where to go. And so even if they're not successful in mental health court diversion, even if they only do 4 months out of the 12 or 1 year out of 2, at least they've gotten assistance from that time period and been provided resources that they may go back to if they decide to get back on the path again. So it's not a failed situation when you're provided the opportunity to have treatment. It can't be a failure, even if they don't successfully complete diversion.
I have just something
I
quick
wanted
to
to,
add
I
to
think
that
I
after
need to,
David's done.
sorry, Doug, go ahead.
I can wait. You can go before me. I don't have any problem with that at all.
I wanted to echo something that Judge Ayers was talking about, and it also, what I was thinking about hooks into the next question, which is really the big philosophical question. So a lot of people that we see in this program and also in the mental health court are people that we've talked about that cycle in and out. They wind up having an episode where symptoms increase, they wind up out in the streets, and they have law enforcement contact, and they wind up in the system. I could never overestimate how important it is to have probation as a law enforcement presence in this program. And when we were sitting down at the beginning of this thing, we started out without probation for a brief period, and there was discord within the group about whether probation should be a component of the team. And I will tell you, based on, clearly it's anecdotal because we don't have this longitudinal statistical information yet, but for the first time in their lives, they have a positive interaction with people in uniform. And those people in uniform are part of this support team. So I agree that it seems overwhelming, 12 months, 24 months, are they going to make it through this thing? As Judge Ayers talked about, and as Declan talked about, this isn't a punitive situation. Everybody's rooting for these participants to complete this program because it's giving them skills that they can use as they go forward, whether or not they wind up, reoffending somewhere down the line. But for so many of our folks who get resisting arrest charges, obstructing law enforcement charges, I think we're going to see those people learn to have a different approach possibly with law enforcement because they've had this positive interaction over a long period of time. It's really good, it's really helpful, and it's worth it. And regarding, well, I guess that's enough because I'll wait for the next question to be read.
What I wanted to add to this is I want to brag about the way that Ventura County does this. As a private defense attorney, I have cases in Los Angeles as well. And I have a client who I got on a 2-year mental health diversion in Los Angeles, and he's seeing the judge maybe every 6 months or so. And I'm going in and appearing, and he doesn't even have to be there. Now, you compare that with this team where you've got all of these people who really have a vested interest and really care about the well-being of the person who's going through the process. We talk about people falling through the cracks, right? I care a whole lot about my Los Angeles guy, but I'm not checking up on him every week. We're checking up and he'll reach out to me when there's a problem or a challenge. But because sometimes there might go 3 or 4 weeks between me being in touch with him or not, I didn't know he got kicked out of a program because he didn't let me know, and I'm not calling every couple of weeks to check in on him either. This team does it completely differently because we've got probation looking out for them, because we've got mental health looking out for them, because you've got Judge Ayers who cares about these people and wants to hear about what's going on with them on a regular basis. We can all, as a group, course correct. They're not going to fall through the cracks because they're coming back on a regular basis. And that's what makes this program in Ventura County special and successful. And Los Angeles is, everybody's doing their own thing, and every single different courtroom has their own policy within the entire larger Los Angeles system. We're doing it right here, and you all should be really proud of the work that this mental health diversion program and the way that it's being implemented in Ventura County. It's actually doing it right, and it's making sure that these people don't fall through the cracks.
And I have just one quick comment about the concerns about the rigidity of the program. This program is definitely a very living and real thing. And, when the criteria is set forth for the clients, it's not the expectation that they're going to run this perfectly for 12 to 24 months. As we know with people with severe mental illness, there are ups and downs, and the program recognizes that as well. And we're going to do our best to adjust as those issues arise. So I don't want you to think that you wouldn't want your loved one in this one because one mistake is going to get them kicked out, because that is, not the case in 99% of the situations. There's always going to be, some mistakes that are going to get you kicked out. But for the most part, the team is really working to keep people in treatment and addressing these mental health issues because the criminalization of mental health has been going on for too long, and we're really trying to address that aspect of it.
Okay,
I
so
think the numbers speak to that reality, and I wonder if Judge Ayers, you might just take a minute to sort of talk about, from your experience, what has put you in that undesirable position of having to exit somebody from the program? Because, like Mr. Torme is saying, it's a last resort, and I think we want people to know that that's indeed the case here.
Oh, well, the conduct has to be pretty egregious in order to completely exit, excuse me, someone from mental health diversion. The main common theme that I see is that someone basically is refusing treatment. And you can do that in a variety of ways, but that's what the bottom line is that the person is not participating in treatment anymore. They're not willing to submit to the requirements of behavioral health. They want to dictate their own treatment plan. They go back to using narcotics in addition to that because they don't want to take their prescribed medications. And I think we're all familiar with that, but it manifests in different ways, but it ultimately is a refusal to comply with treatment requirements. And those also have different results. It could result in a new arrest. It could result in threatening members of the mental health diversion team, which we've had. The behavior is just no longer acceptable for someone to continue in the diversion program. And we've given people, like I said, the reason we have 5 pending right now is because these people are all in the process of being given new chances. We haven't actually had their diversion violation yet because we want to give them ample opportunity to show us that they can't participate anymore before we terminate them. So did that answer, Dr. Shipper?
Oh, it's a good segue to the next question.
okay. Are there any bills currently out there in upcoming elections to get more help for people with mental illness? That's the first part of the question.
I can answer that. I'm on the statewide mental health committee not diversion, but mental health committee for the judges. And there are a number of bills. I don't have the summary in front of me, but none of them are going to be a fix-all. But there's a couple of those that deal specifically with mental health issues, and none of them are earth-shattering, I can tell you that. But yes, there are some.
Okay, the second part. How can families help their loved ones get help if the law still requires the sick person give permission to the family members?
Yeah, that's what I was referring to as the $1 million question, right? That's advocacy. That's you guys calling your state legislators and advocating for changes in the law. Way back, I think it was during Ronald Reagan's governorship of California is when massive shifts happened with the mental health system in California and basically shut down locked facilities in favor of a more compassionate treatment model. And there's the Lanterman-Petrus Short Act was enacted, which, did away with any ability to involuntarily conserve people to a large degree. Different requirements necessary, made it much harder, which is good because abuses were happening. But you know how everything goes, it's like a pendulum, we swing back and forth. So one of the unfortunate consequences of that is it really did drive mentally ill people into direct contact with law enforcement. And that's why right now, the criminal justice system winds up being the repository for people who have reached rock bottom and who have unfortunately found themselves in conflict with law enforcement. And that's this bill, and this program is baby steps starting to remedy what have clearly has been a situation that is not working for the benefit of our mentally ill population.
I have a different take on that because we represent folks in LPS conservatorship proceedings, probate conservatorship proceedings, and other proceedings at the psychiatric hospitals. And I'm also a member of the BHAB, but I'm not speaking on behalf of the BHAB. And so, which is the Behavioral Health Advisory Board, is what the big issue with treatment, residential treatment, isn't so much the demand side, it's the supply side. There's plenty of demand for folks who need intensive residential treatment. It's the supply side is that there's insufficient supply to place these folks, or folks that have meaningful treatment. And this is the thing, is that folks need to also understand is that we're talking about in the context of the LPS conservatorship arena. It's like we're talking about involuntary hospitalization. And so that means that the state or the government is saying, you no longer have a choice of what the nature and course of your treatment is going to be. And so we need to have due process protections with respect to when we get into that. Because as Maeve said, is that there were abuses, and there are no perfect systems out there that I'm aware of, whether here in the United States or in other places. But it's important that, the pendulum doesn't swing too far to where if someone's clinically depressed and all of a sudden their world's being turned upside down because they're being involuntarily hospitalized. And so what we need, what I think more than anything else, is more resources out in the community so that we can have a spectrum of care that's appropriate to the needs of folks, depending on the severity and extent of their mental illness, as well as how acute they are in that moment, and a variety, taken into a totality of the circumstances approach.
I would like to add to that. Because I am on this committee, I hear things from judges in different counties, and the same thing with the implementation of the mental health diversion program in the different counties. The counties that have the most money have the best programs for the most part, because, as Michael says, they have the best resources in place already. And it's really shocking to see. I mean, I think of our county as a fairly affluent county, but when you compare us with Los Angeles County, because of its immensity and its tax base, they have so many residential live-in voluntary programs that provide wraparound services for people that the courts have the ability to use as part of a treatment plan. And we have almost none. And, I don't see any improvement in that inside either, given what we have, what I see. But it would be wonderful to have a lot more resources available to us and available to behavioral health to use for, a place to live, a safe place to live that will help somebody with their medication and oversee it. So anyway, that's my comment.
So just a statement at the end of that question was, a person with a mental illness being in charge of their medical treatment is like a dead person voting in an election. So there's one more question, and it's this. My son is bipolar with schizoid tendencies. He currently is in diversion program with a private treatment center in Los Angeles. He is in this program as there wasn't any help through Hillmont Psychiatric Hospital and social workers. I was informed there weren't any residential place available through Medi program. I had to struggle on my own to find my private placement, incurring a lot of cost. Where are we with helping families with residential mental health treatment in VCBH? There seems to be no help.
Guess I
So it's-
find myself wanting to respond to this one. And frankly, I would like to invite whoever wrote the question to reach out to me and provide me with the details, because I'd like to know more about the situation. This is one of the challenges. Individual situations have all sorts of details and complexities that sometimes influence things, and it's hard to know. I guess and you kind of just heard this in the last response. Basically, Ventura County finds itself in kind of a moderate sort of a position with regard to, resources. There are a lot of counties that struggle to a much greater degree than we do. And then there are other counties that have far more resources. I worked in LA County before I worked in Ventura County. I worked in LA County Jail before I worked here. And so I have some sense about LA County, and while they are in some ways richly resourced, they're also, you don't probably need me to tell you, they're also taxed and challenged in all sorts of ways that don't exist here. The size of the scale of the problems that they confront are really quite daunting. At least to me, it's quite daunting. So it's, but again, I think part of what I maybe see in this question is something that I also heard Dr. Rodriguez saying, which is that really the goal is finding client-centered, the right fit for the right person. There isn't a one-size-fits-all for anybody, let alone anybody in mental health diversion. And, finding the right program oftentimes is all the difference in the world. Difference between success and something other than success. So I'm sorry that if it felt as though it seems to have felt as though help wasn't as readily available here, and I'd like to hear more about that. So I invite the person to reach out to me, and I don't know if anybody else had any other thoughts or reactions.
So just two statements. Agree to probation shout out. VC probation has been sensitive, helpful, and kind. They advocate for my son, even though the court did not listen to their recommendations. And one other statement. Thank you,
I'm sure
Judge
that wasn't Judge Ayers, though.
And there's one more that says, thank you, Judge Ayers. Hallelujah. And then one other question that says, if an adult bipolar felony patient needs psychiatric counseling and meds, can they order all three to prevent harm and hopefully shorten treatment?
I'll answer that. The short question is no. Our jail does not have the license and authority to involuntarily administer medication. They do provide psychiatric medication to people who are in custody who are willing to take it, and they have very good staff psychiatrists in the jail. But we can't force medications in our county, with a few tiny exceptions. The other parts of the question were a felony bipolar, and I answered the medication component, but there's 3 parts to the treatment. Could you repeat the question for me, Roberta?
It says, in an adult bipolar felony patient needs psychiatric counseling and meds, can they order all 3 to prevent harm and hopefully shorten treatment?
The medication aspect, no. Placement can address many of those instances, and there's never a promise result. With people who have serious mental illnesses, you can provide what you can provide and hope they continue to take their medication and remain stable, but there's no, in my opinion.
Okay.
On a less formal basis, the court theoretically can order the person, you must take your medication, You must go to your psychiatric appointment. You must go to group counseling and meet with your therapist.
On
But
diversion.
we can't on diversion, but we can't force them to take medication.
It can be part of the, it can be a component of the treatment plan.
Correct.
And basically what you're seeing there, at least from a behavioral health perspective, is that we look for ways to incentivize people to make good choices, healthy choices, choices that promote their own recovery. So diversion being one of those ones. Look, you can avoid adjudication, you can avoid all that comes with that by complying with treatment. This is a good choice for you. Then again, the hope is the person will recognize the inherent value in that. And that's generally a more favorable approach than sort of trying to force people. You can usually go only so far in forcing people to do things. And when you have the opportunity to take a more authoritative approach, it's really sort of inherent upon the treatment provider to try and use that time to lead the person to the understanding and the appreciation for themselves that, oh, this is something I'm going to want to continue to do even when I'm no longer forced to do it. But again, the circumstances in which you can force someone's treatment is pretty much reserved to conservatorship and acute hospitalization.
So I know we're right on time to end, but there's one more that says 100% there has to be focus on having more services available in our county. How can NAMI help grassroots organizing for making this happen? And I'll just say NAMI will never give up advocating for more services for the seriously mentally ill in this county. So we will keep up with that. And then it says NAMI, CIT officers, and VC POP have been very helpful. The courts are at least a resort when all hope is lost. Need resources to nip in the bud on the front end. The legalization of drugs, high potency, is not helping with our youth. So with that, I have to thank all of you for participating today. We certainly appreciate you all making this happen. And like I said, we did record this and we will put it out along with the slide presentations that more of our NAMI membership and citizens of Ventura County can see this panel today to reach out and see what you're all doing in our county. So again, thank you. Don't know, Dr. Shipper, if you want any closing words to it, but I just can say thank you from NAMI Ventura County.
Well, just thanks for giving us the opportunity to talk about the program. Obviously, people feel very strongly about those involved are very committed and passionate, and we appreciate the chance to talk about it and field questions.
So again, thank you all again for participating today.